Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
Good morning. This is Morning Cannolis, and it's also Saturday, June 3rd, 2023. Thank you so much for joining me on this beautiful morning here in Waukesha and throughout the state of Wisconsin. It is a special morning, a special broadcast here on Morning Cannolis. This is our 50th broadcast, the 50th time through the auspices of Civic Media. We've come into your homes, your businesses, your cars, your public areas. Thrilled to be still on the air talking with you about the important news stories of the day. This is our weekly review, our analysis, our discussion of those important events, those important circumstances, those stories in law, in government, and in the aspiration for justice in America. We do this every Saturday morning from 9 to 11 o'clock. Delighted once again to have you with us. And by us, I mean not just me, but also my wonderfully professional and always engaging producer, Anya, who is with me here at the studios of WAUK here in Waukesha. Through Civic Media, in recent weeks and months, we have been broadcasting not only here at WAUK in Waukesha, listening audiences throughout this area, but also to WMDX in Madison, WXCO in Wausau, WFHR in Wisconsin Rapids, WRCE in Richland Center, WLAK in Emory, WISS in Oshkosh, and WGBW in Green Bay, throughout the state of Wisconsin, through Civic Media, bringing you our weekly discussion again about law, government, and the aspiration for justice in America. This morning, celebrating our 1 year on the air. Always delighted, as in past weeks, to have your phone calls. Always delighted to take your comments, your questions, your objections, your perspectives on things that we talk about in these areas. That phone number, as you know well, is 844-967-2789. Once again, 844-967-2789. And although this is our 50th special broadcast, a couple of wrinkles, a couple of new things being introduced this morning, which we will talk about. As always, our syllabus this morning is ambitious, but hopefully achievable throughout this hour and next hour. Hopefully also educational and maybe even on occasion inspiring to do important things in our lives, in our livelihoods. And we always ask, as we address these questions related to the news stories of our lives, three important questions, three important inquiries. We ask what happened. What do we know with certainty? Important to focus on the facts, not speculation, but what we know with certainty. Also acknowledging, of course, along the way, when we do not know things, when we are not prepared to discuss those things that are not yet known in the public domain, and lots of what we talk about necessarily involves investigations, both civil and criminal. We don't know a lot of things. Eventually we do, but we adhere to the notion that facts are important, and that as a part of one of our first questions, we always ask, what do we know? What do we know for certain? What do we know about the world in which we live? Second, why are those facts important? Why are they relevant? Why are they material to understanding the way in which we live our lives here in the United States, right here in the state of Wisconsin? Why are those things significant to us? Why should we care? And third, what do we do about them? We can't always do something about everything that happens in our lives, and certainly in these areas of government and law and justice. But there are many times in which there can be a response. There can be an appropriate reaction. What do we do in terms of answers to those things, those questions that we raise here on Morning Cannolis? This morning, again, our 50th show, our 1 year anniversary, no exception to that past agenda. Also no exception to soliciting your comments, your questions, calling into us to chat about these important issues. We do have, as always, a very aggressive, a very chock full syllabus this morning. Let me tell you a little bit about what we're going to be chatting about this hour and then next. In past broadcasts, we have initiated a new segment called Undiscovered Justice, identifying those times, those circumstances, those events where things have happened sort of under the radar, not on the top headlines of our newspapers and even in our news feeds. A couple of stories this week on this 50th broadcast about property, about territory, about land, real estate. Undiscovered Justice, things going on to promote justice in America. One of them having to do with our indigenous populations and some lands in New Mexico. The other having to do with some properties, some coal properties in West Virginia. We're going to talk about Undiscovered Justice right at the top of our show this morning in this first hour. Then we're going to talk, of course, as we often do, about matters related to January 6th, matters related to Mar-a-Lago. Lots of stories this past week involving our former vice president, involving our former president, and discussing not only the status, again, of what we know about some of those investigations, some disclosures made just this past week that affect the pursuit of those investigations, or in one case, the decision not to pursue them. Also, big news this past week. And then also talking about a pending case in New York. We've talked about that a lot before, and a judge and an attempt to get him off that case. We're going to chat about that also in this first hour. Then we're going to be initiating a new segment today called Rule of Law in Snapshots. We spend a lot of time talking here on Morning Cannolis about the in-depth issues, the specifics of cases, often specifics of events, why they're relevant to the rule of law. We're going to spend a little bit of time talking about 4 different matters, many of them following up on stories that we have talked about in the past. To talk about 4 of those in snapshots, not spending a huge amount of time on them, but updating you and describing once again the reason why it's important to remain current on the stories that we have talked about in previous broadcasts. Rule of law in snapshots, and then, as you know well, if you have been listening with us, and I suspect that you have for a long period of time, we're going to be spending a good deal of time, mostly in our second hour, talking about, yes, the United States Supreme Court. We are in that time in the United States of America when our Supreme Court is issuing decisions every single week that are very significant. We have talked about many of those in the past. This past week, a couple of additional Supreme Court decisions that may not be at the top of the list in terms of earth-shaking matters, but significant when it comes to labor, significant when it comes to false claims and prosecutions of those people or those companies that may or may not be making false claims to the government. We're talking about those cases and then recap just a bit some of the cases that we have talked about before in the areas of water pollution and internet liability and intellectual property. All things already decided. Looking forward to spending much of the month of June talking with you about these other major cases that the Supreme Court is going to be issuing almost certainly on several days, many days in this month of June as we go into the 4th of July holiday. This is that time of year when our United States Supreme Court begins to clear its docket, if you will, and finally issues those cases. About 60 different matters pending before the United States Supreme Court in this 2022-2023 term. And yes, they're already beginning to stockpile cases for the next term that begins in October of this year. We won't get to that today. We'll talk about those cases down the road. But today, again, a focus on the Supreme Court, past and present, and those things it's deciding in these moments in our lives. Let's talk first this morning. Let's talk some undiscovered justice, some undiscovered things that are out there, accessible to all of us, some good news, if you will, in terms of the promotion of the rule of law. Let's talk, first of all, about this major event happening this past week involving a Native American cultural site. The administration of President Joseph Biden took some very major action just yesterday, just Friday, to block some new oil and gas leasing opportunities and options on some federal lands that surrounds something called the Chaco Canyon in New Mexico. It's one of the nation's oldest and most culturally significant Native American sites. We know well that for the first time in our history, we have a Native American Interior Secretary, the Department of Interior. It's headed up by a woman named Deb Haaland, Haaland, and she, once again, the first time we've had an incumbent in that all-important spot who is of Native American heritage. Deb Haaland announced, Secretary Haaland announced this past week that her agency would be withdrawing public lands, taking off the market, if you will, within a 10-mile radius of this Chaco Canyon and the area around it. It's known generally as the Chaco Culture National Historic Park. And she's taking those lands off from access to new oil and gas leasing for, yes, that's right, 20 years, for 2 decades. And that follows, of course, a pledge that she has made previously, a pledge that this administration has made previously to do just that, protecting this area from drilling, ensuring that future generations, not just of Native Americans, but all of us have access to this important history about the lands that we now call America, the lands that are still indigenous lands, and in many cases owned by virtue of treaties and by virtue, most importantly, of heritage and history by our Native American populations. The move announced by Secretary Haaland this past week will not affect some existing oil and gas leases on land or drilling on private property within the 10-mile radius, but it does once again carve out this major area, this major Chaco Canyon area. This plan in particular is intended to underscore the government's general commitment to focus on Native American issues and expand, as we have seen in other situations, the conservation of our public lands, again, for our future generations. A very important thing, a commitment not only that this administration has made, but other administrations of both Republican presidents and Democratic presidents to preserve our lands. Undiscovered justice in many ways. There's no doubt that this particular canyon park, it's an area about 30,000 acres in what is called the high desert mesas of northwest New Mexico. It was established way back in 1907. 1907. Who was president then? It was President Theodore Roosevelt. A UNESCO World Heritage Site. It is home to this vast network of pre-Columbian ruins, and that's why this is so very important historically for our nation and the history of those peoples who've lived in this property on this land before the United States was here. Between the 9th and the 13th century, get this, the area was a center of Pueblo culture. It had multiple settlements of multi-story houses, the kinds of things we have seen not only there in the actual site, but also, of course, in images, paintings, renditions of what we believed that civilization looked like in the past. Sacred sites on this property as well. For the past decade or so, Pueblo and some other Native American groups there have worried that the oil and gas projects were threatening the park, threatening the heritage, threatening the legitimacy, the continued legitimacy of all of these kinds of things established way back in 1907, again, attempting to commemorate and to preserve history that goes back long before that. Today marks an important step in fulfilling this administration's commitments to Indian country. That's what the secretary said, protecting Chaco Canyon, this sacred place that holds deep meaning for the indigenous peoples whose ancestors have called this place home since time immemorial. That's what our Secretary of Interior said at the time. Right after the break, I'm going to tell you a little bit more about what this administration has also done in this general area. Undiscovered Justice this morning on Morning Cannolis to begin our 2-hour discussion of the rule of law, government, and the way in which we are placed inside all of these issues here in the United States of America and here in this great state of Wisconsin. Thank you for joining me. Stay with me for this important discussion this hour and next.
I ain't blind and I don't like what I think I see. Taking it to the street. Taking it to the street. Taking it to the street. No more need for
We are back this morning on our Morning Cannolis broadcast, talking once again about the rule of law, the administration of justice in America and the state of Wisconsin, and your role, our role in making all of that work. Beginning our broadcast this morning by a special invocation of our sometime segment called Undiscovered Justice, and talking about the fact that the administration, the present administration, has banned drilling around this major Native American cultural site called the Chaco Canyon in New Mexico, discussing in particular the reason for doing that, to preserve not only the history of that from the past, but also for the future. A park that was established way back by President Theodore Roosevelt way back in 1907 at the time of the announcement of this ban for 20 years from new oil and gas leasing on this very important place of heritage for our Native American populations. The Bureau of Land Management Director, her name is Tracy Stone Manning, said this. She said, the exceptional landscape in the greater Chaco region has profound cultural importance. Today's announcement, again, this ban on oil and gas leasing in that area, marks an important step in ensuring indigenous voices help inform the management of our our public lands. Yes, indeed, a significant thing that our government can and should do to ensure that we all have access to these beautiful sites, these important sites that underscore once again the history of this property, this real estate, this land, which we now call America, which our Native American populations still have claim to by virtue of the fact that many, if not all of them, are sovereign nations inside our nation. We know as well that the Supreme Court has wrestled with this issue of the involvement of our Native American populations historically, the significance of treaties entered into by our Congress, by our former presidents, and the establishment of a sense of inclusion and shared vision among our Native American populations, among all Americans for the future. That advanced significantly this past week by the declaration that at least for 20 years, this particular site in New Mexico will not be spoiled, will be accessible for Native Americans and for all Americans to revel in our history and their history in this important part of our nation. A second story also revolving around land and the involvement of the United States Department of Justice, your government, in preserving it for the future. This one's a little bit more grisly, not quite as celebratory because it, yes, involves lawyers, it involves courts, and involves fines, the imposition of fines for entities that have not, in fact, preserved our natural resources. Just this past week, the Justice Department, the U.S. Attorney General Merrick Garland announcing a lawsuit on Wednesday against a major coal empire. Some companies there are seeking $5 million in unpaid civil penalties and fees. The principal defendant in this case, among others, is the son of the present governor. His name is West Virginia Governor Jim Justice. His son runs the family's coal operations, and along with him, there are more than a dozen companies that own and operate these companies in West Virginia. The companies, according to the Justice Department, again, this is an allegation in a civil complaint filed just this past week, repeatedly violated federal laws that oversee coal mine operations. What do they say in particular in this civil complaint filed once again by your government? It said over a 5-year period, the defendants in this particular case, again, a civil matter, including the son of the present governor and other defendants involved in the coal companies there. These defendants engaged in over 130 violations of federal law, posing health and safety risks to the public and the environment. That was the statement made by Christopher Kavanaugh, who is the present U.S. Attorney for the Western District of Virginia, appointed by this president, confirmed by the United States Senate. And that's the statement that he made at the time that his office filed in the federal district court, not the state court, the federal court in West Virginia, this major civil action to enforce the environmental laws and to seek the imposition of penalties for the failure to abide by the conditions, the terms of those laws. The U.S. Attorney then went on to say, after given notice, these defendants failed to remedy the violations that were identified and were ordered over 50 times to cease mining activities until their violations were abated or reduced, basically. He said today, the filing of this complaint continues the process of holding these parties accountable for jeopardizing the health and the safety of the public and of our environment. Very significant case once again. Under the headlines, if you will, Undiscovered Justice, significant, plainly. The filing of a civil complaint does not mean that there is the imposition of a judgment yet. That's what trials are all about. That's what pretrial proceedings are all about. That's what the entry of a judgment ultimately would be by a federal district court, whether or not the allegations are sustained, maintained by evidence, by evidence that is credible and reliable in the federal court. But again, this past week, efforts by your government to preserve in West Virginia and in New Mexico these important lands for the future of our nation, our future generations, all of that, Undiscovered Justice, now Discovered Justice, here on Morning Cannolis. Thank you once again for joining me here in the studios of WAK and throughout the state of Wisconsin, all of the broadcast areas of Civic Media. Delighted to have you with me and with my producer, Anya. We, as always, taking your phone calls at 844-967-2789 here on this special 50th broadcast of Morning Cannolis, entering into our second year of broadcasting here on Civic Media. Looking very much forward to that. Looking forward to your continued participation, your listening, your involvement in our discussion about the rule of law, justice in America, and the pursuit of the ways in which we can all become involved in our government to make our nation, our state, better places in which to live, in which to work, in which to raise families, and to reside generally. Let's move on, as we always do, to some significant issues, some significant developments in the rule of law in the area of justice this past week. Again, some of these, if not all of these issues, involving the United States Department of Justice and its investigations involving both the former president, the current president, and a former vice president. Let's begin with that story. We know well that since the summer of last year, actually even before then, the United States Department of Justice has been looking at whether or not the former president, Donald Trump, was involved in taking documents from the White House, arguably some classified documents as well, contrary to law. When we come back, we're going to tell you more about that and the updates not only to that individual investigation, but a significant matter involving the status of the current investigation of the present President Joe Biden, and most significantly, the big news of this past week, a decision by the Department of Justice about whether to continue a similar investigation of Mike Pence, our former vice president, again involving allegations of the acquisition, the taking, the maintenance of documents. Stay with us for that important news here on Morning Cannolis. We are back here on Morning Cannolis. Delighted to have you with me here on this beautiful morning here in the state of Wisconsin, Saturday, January 3rd, 2003, as a part of our regular Saturday morning review of the significant stories, events, circumstances, stories out there in connection with the rule of law, justice, and the administration of justice in America, talking right now about major news involving our former Vice President, Mike Pence, and backing into that story by providing once again the background to it. Right before the break, talking about the fact that the U.S. Department of Justice has for a number of months, coming up on almost a year, if not longer, been reviewing, determining whether or not there is any basis for charging people, perhaps including our former president, with violations of law related to the taking, the acquisition, the maintenance, maybe even the use, the demonstration, the sharing of classified and other documents at his location in Mar-a-Lago, maybe other places as well. That investigation continues to go on under the auspices, the oversight, the supervision of Jack Smith, who is the special counsel appointed, again, the federal government in our U.S. Department of Justice by the Attorney General Merrick Garland. He continues to pursue that particular matter as to the former president, and there's a second matter also involving a current president. His name, of course, is Joseph Biden. In the wake of the appointment of Jack Smith by the Attorney General to investigate, to determine whether or not there's a basis for any charges on the so-called Mar-a-Lago documents case with respect to the former president, the Attorney General then, upon the identification of like documents, perhaps not specifically the same number in numbers or in content and quality, but the discovery by our current president that while he was not in office, after the time that he was the vice president, he had, both at his home in Delaware and at an office in Washington, D.C., some materials that also should not have been in his possession, his acquisition there in the wake of his leaving office. And unlike the former president, the current president cooperated fully in identifying those documents, inviting the FBI in to take a look at what he has had, searching those properties to determine whether or not there are any documents that he should not have in his possession. In the wake of those events, the Attorney General also appointed a special counsel to investigate and determine whether there's any basis to pursue charges in connection with the Biden aspects of this same kind of thing. The Attorney General appointed an individual named Robert Hur, H-U-R. Mr. Hur is the former U.S. Attorney in the District of Maryland. He was a part of the Department of Justice under the prior administration. He was appointed by Donald Trump in the administration that preceded this one. And Mr. Hur, as a part of his assignment by the present Attorney General, determining whether or not, again, there's any basis for assessing, any basis for finding that there were any violations of the law in connection with Joseph Biden's acquisition, his taking, his maintenance of documents at these locations in Washington, D.C. That matter also continues, even as the matter with respect to the former president, Donald Trump, continues. The big news this past week in the wake of all of that history of the past several months is related to the former Vice President Mike Pence. Now, you may recall well that in the wake of the discoveries, this identification of documents in the possession of our former president, Donald Trump, our current president, former Vice President Joseph Biden, Mike Pence, on his own, called upon his attorneys and said, you know what, I would like you to take a look, determine at my home in Indiana whether I have any similar documents that I should not have, that I inadvertently, perhaps like Joe Biden as well, perhaps not like Donald Trump, given recent statements, which we'll get to, if he had inadvertently taken those documents, called upon his own attorneys to do some searching, some investigating, and sure enough, those attorneys did identify a small number of materials in the boxes that were sort of swept up, inadvertently collected at the time that the former vice president, again, this is Mike Pence, left office under the Trump administration. Took those boxes, including some of those materials, with him back to his home in Indiana, called upon his attorneys to identify those. They did. They produced those, again, a small number of documents, nowhere near the number of documents identified already, according to most reporting, out of the Mar-a-Lago location, nowhere near the number of documents there. In the same category, if you will, as the Biden investigation, no purposeful, intentional taking of classified documents. But he identifies this as an issue, no indication of obstruction of justice, dissemination of any of these documents to anyone by the former vice president. And sure enough, this past week, in a statement, a public statement by the Attorney General of the United States of America, the Department of Justice advised the former Vice President Mike Pence that it is not going to be pursuing any criminal charges related to the discovery of any classified documents at his Indiana home. That in a letter delivered by the Attorney General, by the Department of Justice, to those attorneys who represent the former Vice President in this matter, perhaps other matters as well. No criminal charges, no charges at all related to the discovery of those classified documents at his Indiana home. A significant decision for a couple of reasons. One is, of course, it does close out this singular aspect of this whole document issue. The special counsels, again, Robert Hur, with respect to the present president, and Jack Smith, with respect to the former president, those investigations continue. We do not have any charges, any announcements of an official nature coming out of those investigations. But the Department of Justice, in this matter, there was no special counsel appointed, appropriately, no special counsel appointed, principally because until perhaps next week, Mr. Pence has not been an announced candidate for the presidency, fully anticipating that probably in the days just ahead, he may in fact do that, announce his candidacy for the presidency. But this matter did not proceed under the auspices, the oversight or supervision of a special counsel. Instead, attorneys, civil servants of the U.S. Department of Justice reviewing this matter, finding no basis at all to pursue any criminal cases, any charges against our former vice president, Mike Pence in this case. It is significant also just as a pure procedural, maybe even a civics matter to understand what's going on here. We have gotten very used here in America to requiring, almost even demanding that during the course of investigations we get information about the status of them. And of course, most prosecutors, including Jack Smith, including Robert Hur, including others out there who have been special counsels, special attorneys appointed by the Department of Justice to investigate these things, have, for the most part, declined to talk about the investigations. That is appropriate. That is the right thing to do. We do not investigate these matters in the public domain, pursue them through a grand jury, pursue them through processes involving interviews, perhaps with the FBI, other agents of the federal government. We do not do this in the public domain, certainly not through the media. And most often, when cases are closed, whether it's by a U.S. attorney, by someone at the Department of Justice, by the Attorney General, others, similarly, it closed without any identification of criminal culpability, no charges being issued by a grand jury, no charges being proposed to a grand jury for indictment. Most often, we do not hear about those either. Why? Because that's appropriate not to be disclosing that. Even the fact of a pendency of an investigation may tend to taint the public view of someone. Criminal cases are closed all the time when there is insufficient evidence to show that there has been a finding of a crime. Sometimes there is a belief, perhaps among the prosecutors, among the investigators, that a crime did happen, but there's simply not sufficient evidence, documentary evidence, witnesses coming forward. And for that reason, too, it's closed. And very often, it turns out that during the course of an investigation, what's an investigation for? It's to investigate, right? It's to find out whether or not a crime was committed. If a crime was not committed, there is no basis to go ahead with charges. And I would offer that that's what's happening in this case. Most often, for cases that are not in the public domain, that do not get the kind of attention that this particular matter and others have gotten by virtue of the fact that Mike Pence is our former vice president, those cases are closed without any announcement by the U.S. Department of Justice, by prosecutors, by agencies, and that's appropriate. We do not, once again, to affect the reputation, the credibility of people out there who may have been under investigation, but whose investigations result in findings of no criminal culpability, or at least, at a minimum, a failure to prove enough evidence to support a finding of some criminal involvement. In this case, an exception to that. Why? Because of the public notoriety on this. And there's a public policy inside the Department of Justice that says the Department of Justice, the Attorney General, can, in his or her discretion, announce something that is in the public domain about which Americans rightly have an interest in knowing. Legitimacy about a former vice president's conduct, in this case, would fall inside that exception to the rule. And so an announcement this past week, again, that's not normal, not usual, but this announcement that the former vice president did not engage in any criminal conduct with respect to the documents in his home. That, again, appropriate. Why? Because there's public attention to this matter, public notoriety to it. And the reason for doing that is to ensure the citizenry of our nation that our government is acting competently, that it is attentive to these investigations, and that it will resolve them, hopefully in a fairly expeditious way, but based upon the merits. I would offer that that's exactly what's happened here. An announcement, once again, that that particular matter involving simply the Vice President Pence, not involving the present President Joe Biden, not involving the former President Donald Trump. Those matters still under investigation. But this one, now closed, the file done, and the Department of Justice presumably moving on to other things in its broad ambit. And speaking about those very important things, and speaking about the documents case, let's talk about some reporting of just this past week that goes to this issue of intent. As my comments this morning and in other circumstances have reflected, one of the things that the government, by the prosecutors, the Department of Justice, assistant U.S. attorneys always have to show, first to a grand jury that has to determine whether or not there is probable cause to believe that a crime has been committed, and second then to a trial jury, sometimes called a petit jury, have to show what in a criminal case? In any criminal case, has to show that there is intent. The defendant has to have had the knowledge, the purpose, the mindset, if you will, sometimes called the scienter, S-C-I-E-N-T-E-R. That's the sort of legal term for it, the mens rea, to use the Latin version of this, the intent to do the crime. And if you don't have the intent to do it, if you simply engaged in some negligent act, if you goofed, made a mistake, that may in fact be the focus of a civil action, but it doesn't support criminal prosecution. So one of the things that the government always looks at, I used to look at as an assistant U.S. attorney, as a U.S. attorney at Maine Justice and also here in the Eastern District of Wisconsin, always tried to determine during the course of any investigation, violent crime, white-collar matters, including matters involving documents, what is the intent? What did the defendant, the target of the investigation, intend to do? Was this a mistake of the sort that, again, effectively was announced by the Department of Justice this past week in finding that, yes, Mike Pence had those documents, but did that inadvertently? That was a mistake, all right? Not a criminal matter for prosecution. The question is always whether there is that intent out there to take those documents, to maintain them, perhaps to show them around with a purposeful intent to violate the law. And that undeniably is the focus of at least the investigation being pursued by Jack Smith as to the Mar-a-Lago documents. documents. And this past week, once again, some significant news coming out of that investigation. Again, not certain, but probably reliable based upon some of the appropriate reporting being given to us in the public domain. Again, we know Jack Smith, looking at this determination, this question about whether or not Donald Trump maintained, took these documents, used them in some way, and specifically, what was his intent in doing so? Is this a Mike Pence situation where he simply inadvertently took them to Mar-a-Lago? Probably not. Probably not, given the number of documents, the nature of them, the sheer volume of them, other things we have found out. This past week, some additional information coming out through the media with some reliability that federal prosecutors, again, investigating this handling of classified material, actually have a recording of Donald Trump way back in 2021. He, at the time, was apparently discussing some sensitive military document that he had kept, that he had maintained after leaving the White House, and two people who briefed some of the media on this, provided some reliable information about this. In that recording, again, a taped recording of the former president, Mr. Trump apparently suggested that he knew the document was secret and that he had not declassified it, and that for that reason, a great revelation about intent. And of course, the existence of that recording could undermine Mr. Trump's repeated claim that he had already declassified material or that maybe he didn't even understand the significance of it. When we come back, we're going to talk more about that purpose of intent in investigations and discuss why this particular revelation is so important as this document matter with respect to Mar-a-Lago and the former president continues. Stay with us here on Morning Cannolis for that discussion.
Keep on rolling, Mississippi moon, won't you keep on shining on me? Keep on shining your light, gonna make everything gonna make everything all right. And I ain't got no.
We are back here in Morning Cannolis. Thank you for continuing to join me in our discussion about news related to law, government, and justice in America, chatting in our previous segment about this revelation through the media, probably reliable, that Jack Smith, who is now investigating the former president, his name is Donald Trump, for his acquisition, his taking, his maintenance, perhaps even his using, maybe even his transfer of some of these documents to other people, apparently has a recording way back in 2021, during which the former president at that time as well, he's discussing this military document that he has in his possession. The recording apparently made during a meeting that Donald Trump had in January and July of 2021 with people helping his former chief of staff, that individual, of course, named Mark Meadows. He's writing a memoir of his 10 months in the White House, according to the people who are giving this evidence. The meeting was apparently held at Donald Trump's club in Bedminster, New Jersey, one of his many locations on the East Coast there, and he spends a lot of summer times there. And until now, as I said before, the focus of this investigation has been largely on this material found at Mar-a-Lago, his private club, his residence in Florida, rather than in New Jersey. Here we've got this site in Bedminster, New Jersey, where this conversation apparently happened. According to reporting on this particular conversation, an admission, an acknowledgement by the former president at the time that he's got this document, that it's secret in some way, that it does in fact fall into the category of a sensitive military document, that he has it in a way that he should not have it. On the recording, apparently, Donald Trump also was railing against his hand-picked chairman of the Joint Chiefs of Staff. You may recall his name is General Mark Milley, described in media accounts at the time as having guarded against Donald Trump's striking Iran in the final days of the presidency. Again, a lot of this reporting coming out of this matter relating to the disclosure through the grand jury process, presumably, to Jack Smith of this recording. The recording apparently obtained by the Department of Justice in recent months. Why is it important? Again, it's got to be a key piece in determining whether or not this was inadvertent, whether the acquisition, the maintenance of these documents by the former president was inadvertent, or whether he had the intent to do it. Why is this significant? We don't know exactly what the president said, but if indeed he reveled in the acquisition, the holding, even the brandishing of this document, that goes to his intent, right? He knows he shouldn't have it. He knows the nature of it is a secret military document, and it supports the notion But if indeed Jack Smith and the grand jury that he has convened in Washington, D.C., is looking at this issue of intent under the criminal law to determine whether or not there should be charges against the former president, perhaps others as well, this goes to that issue and certainly supports that conclusion that he knew what he was doing and that he knew that what he was having in his hand, his discussion of it, the sensitive nature of it, all of that goes to his intent, a critical element, again, in determining whether an indictment will be issued and ultimately whether there would be a conviction if indeed indictment, if it comes out of a grand jury, whether a conviction by a trial or petit jury can also be had. That will be the principal focus of any documents case, regardless of how it is charged, how broadly it is defined, what the scope of that may be. This significant news, again, is probably a small piece of what Jack Smith has been investigating for a very long time now, but nonetheless, it underscores the importance of the criminal process and probably his necessary focus on now that he knows what the documents were, where they were located, although there is some indication after this report that the special counsel does not, in fact, have the document itself, perhaps indicating that there are more documents out there. Even in the midst of all of that, it reflects upon the status of that investigation, that Jack Smith plainly now looking at this all-important issue of intent. Jack Smith also looking at broadly things related to the 2020 election, right? That's the second major assignment being given to him by the Attorney General to look at things related to this attempt to overthrow the government, if you will, on January 6th of 2020, to undermine the appropriate findings of the Congress by the Vice President, by the Speaker of the House, that in fact Joe Biden won the presidential vote in 2020, opening those electoral votes and finding that Joe Biden didn't have enough electoral votes to take the presidency. The 2020 election also a part of a separate but probably somewhat related investigation also being pursued by Jack Smith inside the Department of Justice. Well, this past week, again, some additional information coming about subpoenas that were issued by the special counsel scrutinizing the dismissal of a person named Christopher Krebs. Christopher Krebs, his name, you may recall him. He was the one who contradicted openly and overtly these baseless claims by the former president, Donald Trump, that the 2020 election was marred by fraud. And in particular, Krebs at the time had said there's no evidence that any voting system deleted or lost votes, changed votes, or was in any way compromised. And again, that statement made by Mr. Krebs, a part of the government at the time. He was the top cybersecurity official during the 2020 election. And of course, that Krebs assessment that the election was secure was at odds with what Donald Trump was saying about the fraud, as he described it, on the American people. It's plain that Jack Smith is now also seeking information about how White House officials, including the Presidential Personnel Office, approach the Department of Justice, looking at this Krebs matter, looking at other ways in which intent may in fact be established. The investigators, again, probably focusing on Donald Trump's state of mind, his intent, his mens rea, his scienter, as I said, around the firing of Mr. Krebs, which he did. Why did he do that? Why did he get rid of Mr. Krebs, who said these things that, again, were contrary to his position? Well, we probably know why he did that. He was doing it because Krebs was articulating a position that was contrary to what Donald Trump was saying to the world about the legitimacy or illegitimacy of the election at that time. So we know he fired him, that is, Donald Trump fired Krebs to get rid of him, as he has done with other people. But it also goes to the question of intent. If you're firing someone who is indeed articulating a position different from yours about the 2020 election, what does that say about your intent? Well, it says a couple things. It says that plainly this person is telling you there is no fraud here. There's nothing to be seen here, nothing about the election, the Electoral College that is subject to disbelief based upon fraud. And it goes to this issue about what you knew and what you didn't know. In this case, an attempt after that to fire someone who is articulating something contrary to what your own view about the world may be, contrary to what you probably know in the end is the truth, which is the 2020 election was not, in fact, stolen. Again, this pursuit of matters related to the circumstances under which Krebs was fired is another part, this Christopher Krebs fellow is another part of this investigation being pursued by the special counsel to determine what was in the former president's mind at the time. Again, another important issue coming out of this investigation this past week, all related to the pursuit of justice. We'll see what happens probably this summer into the fall, whether all of this related to intent, documents, the 2020 election, results in a series of federal indictments, federal charges against the former president, perhaps against others as well. That is also going to be the subject, plainly, of our discussion here on Morning Cannolis. Stay with us for our next hour as we pursue the pursuit of justice here in America, in the state of Wisconsin, law and government in our state and throughout our nation.
Welcome. Grab your favorite morning beverage and join us for Morning Cannolis with Jim Santel.
You don't know me, but I'm your brother.
Sampling the news desserts of the week, here is your host, Jim Santel.
This is Morning Cannolis, and yes, I am Jim Santel. We're talking this morning, our weekly review, our analysis, our discussion of those most important stories and events and circumstances, developments in the areas of government and law and the aspiration for justice in America. A special morning, a special broadcast here on Civic Media. This is our 50th broadcast. Delighted to be with you over the course of the past year. Looking forward to at least another year on the broadcast studios of WAUK and throughout the state of Wisconsin, all of them on the Civic Media broadcast stations. Looking forward to that, as well as we continue our discussion, our review of all of these important issues. We're going to begin this second hour this morning on June 3rd of 2023. Talking about a number of events that have happened in the past, initiating a new segment here on our 50th broadcast. We're describing that as Rule of Law in Snapshots. Things we've talked about before, providing you with some updates on things that have happened since the time of our initial discussion, our reporting on these stories. Let's begin by talking about a couple of those. Let's begin by a story that we ended with last week, and that was the impending vote by the House of Representatives, basically the Assembly in the State House in Austin, Texas. The vote on whether or not to impeach the sitting Attorney General. His name is Warren Kenneth Paxton. He goes by Ken Paxton, the chief state law enforcement officer in that state. In that position, the incumbent in that position since 2015. Almost immediately after he took that office in 2015, he was charged with securities fraud, a criminal case that continues to this day. Last Saturday, right after we went off the air, the Assembly there in the state of Texas in Austin, basically the House of Representatives, the House of the Common People, if you will, decided in a bipartisan vote, Republicans and Democrats alike voted to impeach, to find charges, find a basis in which to remove the Attorney General based upon various allegations of bribery and abuse of office, obstructing justice, and making false statements, most of them, not all of them, but most of them in connection with his attempts to stop an investigation of a friend of his who himself was under investigation by the FBI. A fairly complicated story, but again, reviewed by the legislators there in Austin, Texas. And again, last Saturday afternoon, hours after we went off the air, the legislature there returning articles of impeachment charges, not findings of guilt, not removing him from office, but returning these articles of impeachment against the sitting Attorney General. The important things to know about this: there is going to be a trial. The Senate now going to be trying this matter sometime before the end of August. So we'll be reporting on this during the course of this coming summer. Significantly, about 31 members of that Senate have got to decide whether or not there is a basis upon which to actually remove Mr. Paxton from this position while he is pending, while these charges are pending, while the impeachment charges are pending. He is basically suspended from doing his duties, but he's not removed. The title has not been stripped from him. So the question is whether or not there is a basis for these charges as presented to the Senate by the House, by the Assembly there and they're going to be trying this case, probably not in the way that we think about a trial in the federal or state courts of Wisconsin or other places around the country. But as we've seen in the federal system, we've had 3 presidents who have been impeached, Andrew Johnson and Bill Clinton and Donald Trump. We've seen, at least in our contemporary history, how some of those trials go. They're not really trials in the literal sense of the word, but presentations about whether or not this particular individual should be removed from office. Of course, the remedy there is not a criminal conviction. It is simply removal, a decision by the legislature that this person should no longer encumber that office. Significantly, the rule of law issue here, of course, chief law enforcement officer for that state, going to be decided by the senators, and among those senators is the Attorney General's own wife. Her name is Angela Paxton, and at least to date, she has not recused herself, not removed herself from that decision, and presumably will in fact go ahead and listen to the evidence and determine whether or not her own husband should be removed from that office. We're going to talk a little bit more about recusal in just a moment or so, offering that under these circumstances, any elected official, any appointed official who has a conflict of interest like this, certainly involving their spouse, should take themselves out of the mix, right? Should not be the one determining what should happen to one's spouse. We have seen this a lot in connection with Clarence Thomas, the Associate Justice of the Supreme Court, allegations that because of his wife's activities with respect to 2020, the election there, and the decisions that the Associate Justice is making along with others having to do with the investigation of January 2020, he should not be deciding those kinds of things. The same concept applies there as here. An involvement with somebody in your personal life, with the involvement, the relationship is just fine, but it should prevent you from making decisions based upon the future of that person, that spouse, that partner, that wife, that husband, whatever that relationship is. We're going to talk in a moment about a judge who got it right. Here in Texas, we'll see whether or not the Attorney General's own wife decides to recuse herself based upon her upcoming review of evidence that her husband may have in fact been involved in these offense conducts. The securities fraud case continues. He has not yet been convicted of anything there. Of course, he's presumed innocent until proven guilty. But all of that pending, a major rule of law issue, again, just in this past week. Let's turn then to a second matter, again, in our rule of law in Snapshots, following up on previous cases, matters that we have discussed in the past. We have talked a lot in the past about DACA, the Deferred Action for Childhood Arrivals Program. Of course, this is the program that in 2012 is an executive order by then President Barack Obama. It allowed eligible undocumented young adults, people brought here by parents, by other supervisors in their lives, who came to the U.S. as children to work and to study without fear of deportation. In other words, they came here when they were children. The question is, how should they be regarded? What is their status since they were illegally brought here? But should we do something by virtue of our overall immigration plans and policies to ensure that because they are here, they've got the right to work and to study without fear of being deported as being illegally here. And again, in 2012, then President Obama implemented this DACA directive order, this executive order. Significantly, at that time, a U.S. district judge, his name is Andrew Hannon, found that the Obama administration, failed to follow administrative rules in launching that program, and so found it illegal, found it unconstitutional, declared DACA illegal, placing all of this very much in jeopardy. And of course, at the time, since then, and to this day, this continues to be a major issue for many, tens of thousands of so-called DACA recipients, more than 580,000 of them living in the United States right now. An overwhelming majority coming from Mexico, other Latin American countries. Today, the average DACA age is about 26 to 28. And again, they're looking for clarity on what their immigration status is and should be. Well, why is this issue back again in the news? Why is it a part of our rule of law in Snapshots? Well, again, coming up, the federal judge presiding over the hearing about whether or not the new version, if you will, the Biden version of DACA is also illegal. It happens to to fall in front of the same judge, Andrew Hannon. What happened in the wake of the previous ruling was that the Biden administration, turned the DACA problems, the things identified by the judge as problematic administratively, went back and implemented some new administrative rules that turned the program DACA into a federal regulation as opposed to an executive order, a federal regulation to increase its chances of surviving some legal challenges. So DACA, again, still remains out there now as a federal regulation, and again, challenged by various states of the country. Those states include Texas and Alabama, Arkansas, Louisiana, Nebraska, South Carolina, West Virginia, Kansas, and Mississippi. All these states alleging now that the very implementation of DACA through a federal regulation is also illegal, also unconstitutional. And sure enough, the district judge, Andrew Hannon, who previously ruled that the executive order was illegal, now presiding over another hearing to determine whether or not this new incarnation of DACA should stand. And of course, we'll continue to report on that as well. Plainly, we have got tens of thousands, 580,000 DACA recipients, and all of us should be looking at this because we're concerned about immigration. We're concerned about people, the status of them in this country, especially of these young people, now 26 to 28 years old. Again, the program, through the regulation and through the executive order, previously granting them the right to work here, to study here without fear of deportation, giving them this shield, if you will, even while the United States Congress does not do its own job in implementing an omnibus immigration policy. That, again, an update to what we have talked about before. Let's talk about one other matter that's also been on our agenda in the past, and that is this case involving Disney and the present governor of the state of Florida. You may recall well that in recent times, the governor, his name is Ron DeSantis, who is also now a candidate for president of the United States of America, has been sparring with Disney, initially over some disputes. You may recall in Florida, the state legislation on LGBT teaching, sometimes called the Don't Say Gay law. Well, the leadership of Disney World there in Orlando, said, we're not supportive of this legislation, of this law that was passed and signed by the governor. And that attracted his attention. And the governor began to retaliate, at least according to the Disney folks and many other people out there. He began to change the governance of the board that oversees the properties there, began to threaten the Disney World institution there, its ability to govern itself, its own properties there. Authorities for oversight and management of the board of directors. Great disputes between Disney and the governor, all ultimately related to this LGBT legislation in that state, but resulting in state and federal legislation. Along the way, Disney files a piece of litigation in the federal district court there. The company leadership in the Northern District of Florida says that the governor and the government of the state of Florida has used its political power for government retaliatory purposes, doing all these things to affect us in a way that's inappropriate, alleging a First Amendment violation. And in that connection, the case given to, randomly assigned to a federal district court judge there. His name is Mark E. Walker, Walker. And interestingly, he ruled previously against the governor in a separate action, unrelated to the Disney matter. When we come back, I'm going to tell you about a very important thing that happened, that this judge made a decision involving recusal that is at the top of our list this week for appropriate things that legislators and executive branch, and in this case, a judicial officer, have done to promote the rule of law. Come back as we tell you about what this judge decided in this case just this past week. We are back here on Morning Cannolis. Our next segment, part of this current segment called The Rule of Law in Snapshots, following up on issues, cases, developments, stories in government and law and justice we've talked about before that requires some updating. And specifically talking right now, before the break and currently in this segment, about this sparring that's going on between Walt Disney World and the Disney companies and the governor of the state of Florida, Ron DeSantis, having recently been announced himself a candidate for the presidency of the United States of America, picking on Walt Disney and Mickey and Minnie Mouse. Again, according to the litigation that has been filed by Disney, alleging that the governor and others have used their political power for government retaliatory purposes, a violation of their First Amendment rights, attempting to undermine their capacity to speak out, again, in connection with this LGBT teaching legislation that now, regrettably, is a part of the law in the state of Florida. Along the way, the case gets assigned to Mark Walker. And what did he do this past week? Amazing. And it is an affirmation of the rule of law. It is perhaps one of my favorite stories from this past week, again, in our rule of law in snapshots, certainly, but beyond that, it stands alone. In a time when we have reason to doubt, especially when it comes to our own Supreme Court, the legitimacy, the independence, and we wonder about the appropriateness of judges and justices continuing to preside over cases in which they have personal economic interests, personal relationships that may affect their decision-making process. Here we have a judge who did just the opposite. Here's the story. Mark Walker, again, a federal judge, announces this past week that he is going to recuse himself from this spat, this federal litigation involving Disney and the governor, this First Amendment case. Why? Because he announces that there's a member of his extended family, again, not his nuclear family, presumably not his spouse, his partner, not children, but his extended family. We don't know exactly who that is. Could be a brother or sister. Maybe it's a cousin, maybe somebody out there. But that cousin or that person out there in his extended family owns Disney stock. Okay? And the judge says, the fact that that person in my extended family owns Disney stock, that could be substantially affected by the outcome of this case. And he says, I don't want anybody to suggest that anything I do in the connection with the resolution, the oversight of this case involving Disney and involving the governor in the state of Florida would be affected by the fact that my extended family member has stock in Disney. And so he says, rather than to suggest, give anybody some grounds to believe that I'd be biased, I am going to recuse myself. An important thing to say publicly, an important lesson to teach all judges out there. He gets it right. Probably he bends over backwards. There are an awful lot of people, I think, would look at this and say, well, if you've got somebody in your extended family who happens to have some stock, you yourself may not profit directly from it. This judge says, I'm going to take a very broad view of the recusal standards. I'm going to get myself off this case. Another judge can handle this who maybe doesn't have that same connection. Why is that so important? Why rule of law and snapshots? Well, it follows up again on this Disney sparring with the governor, appropriately sparring with him about what's going on there, but also sending this great message about what recusal means, what it should mean for everyone, including derivatively the spouse of the present attorney general in the state of Texas, who may be deciding on the future, the fate of her own husband. She should recuse herself. Associate Justice Clarence Thomas should be recusing himself in matters in which his own spouse has some involvement, and also should be recusing himself, of course, in those cases in which a fellow named Harlan Crow, through his companies, may also have had some involvement in cases. Recusal, a great lesson being taught to us this past week by Judge Mark Walker in the Northern District of Florida. Good for him as we go forward. And finally, in the rule of law and snapshots, one more story I wanted to follow up on. This one, very, very grisly. We know from just this past week that after a number of weeks of jury selection in the so-called Tree of Life prosecution in Pittsburgh, that the gunman there, the gunman, his name Robert Bowers, in an October morning of 2018, goes into the Tree of Life synagogue that houses three Jewish congregations. He kills 11 people, injures many, many others. He has a small arsenal with him, goes there and quite literally mows down members of those congregations. They're to do what? To worship as they want, to worship as a part of their right in America. And, of course, in the wake of that, a huge amount of discovery, by investigators, discovering on his websites, his social media postings, a huge amount of not just anti-Semitism, which of course is highly relevant to this, talking about wanting to kill Jews, talking about his misogyny, his homophobia, his racism, his sexism. They're all there in the things that he has posted. And so Robert Bowers, charged in the federal district court there in Pittsburgh with hate crimes in connection with the killing of these 11 people way back in 2018, opening statements just this past week in that case. It will surely go on for a number of weeks here to determine whether or not he should be found guilty of those federal offenses, hate crime offenses involving the congregations there, the Tree of Life congregation, the New Light congregation, and the Dor Hadash congregation, all there in Pittsburgh. The prosecutor describing this past week the conduct of Mr. Bowers in the sanctuary and the refuge of this holy place, disturbing that sanctuary, and describing that he was making his own preparations in advance of that to destroy, to kill, and to defile that sanctuary. The defense has plainly indicated they're not disputing the fact that he did this. The question, once again, is going to be about intent. And his own attorney, in the course of her opening statement, acknowledged the grisly nature of what he had done, said this is a straightforward question, not of whether he committed those murders, but requires a determination of motive and intent, and that's what this case is going to be about. Ultimately, as we've talked before, this case is going to be about whether or not Mr. Bowers, who again does not dispute the fact that he did this, should be on the receiving end of a death sentence by this jury, or whether he should be found guilty and sentenced to life imprisonment. A huge development this past week, the Tree of Life killing, the Tree of Life hate crime there in Pittsburgh, here as a part of our Rule of Law in Snapshots review. When we come back, we're going to take one of our callers and also taking your callers at 844-967-2789. Stay with us for our further discussion here on Morning Cannolis.
I know you're not mine anymore, anyway, anytime. Tell me how come we're not in love anymore? How come things will never be the same?
And we are back for this final half an hour this morning, June 3rd, 2023, here on Morning Cannolis. Thank you so much for joining me. This is our 50th broadcast, celebrating here the studios of Civic Media here in Waukesha and throughout the state of Wisconsin, celebrating, as always, our callers, which we appreciate. And we do have a caller on the line. Joe, thank you so much for calling in this morning from Madison. Your comment, your question, your observation here on our 50th show, our one-year anniversary. Glad to have you with us.
Thanks, Jim. And I had a question and a point to make. The first point to make is congratulations on
Thank you.
the show. We are very, very lucky to have you giving us information, and I sure appreciate it. You had said something along the lines of God willing over the next year, and I'll tell you, I really, really hope that you are here to be able to explain to us the legal complexities of what we're facing in our country these days. So thank you so much.
Well, thank you so much for that, Joe, and appreciate, again, your involvement in that, your participation. Always great questions, and I suspect we've got one coming up right now, so go right ahead with that, too.
Yeah. I so appreciate being able to get more clarification. In your last hour, you were talking about the situation of ex-President Donald Trump and his brandishing, apparently, of a memo that had to do with military matters, and where this what this means for Jack Smith in terms of his building his case against the president. The question I would have is, and I'm sorry if this it seems quite stupid, but I'm sure if I have this question, others may too. You mentioned in passing that they don't have a copy of this letter that the ex-president was brandishing. So my question is, so they must know this document exists by the content of it, and then I'm also guessing if it is a classified document, it is somehow noted by some kind of numbering system, I'm guessing. And then my question after that is, So they're surmising the document has to, from what the president has said, it has to do with this subject. So the question I would have is, do they need the document in order to build the case? Or in a certain way, is the fact that they can't find the document says even more about, well, the president must have it and he shouldn't have it, and thus that builds the case. So I'll take my answer off air, but I was uncertain as to how that affects the building of this case that Prosecutor Smith is working on. Thanks a lot, Jim. I appreciate it.
Absolutely, Joe. Always delighted to have you a part of our Saturday morning program. And again, no exception to always your thoughtful and good questions. Not at all inappropriate or somehow factually unbased. Just the opposite. It's a great question. It's exactly the kind of thing that Jack Smith is probably wrestling with right now. Let me unpack that a little bit, because this does go to investigative stuff. It goes to the process by which investigators look at evidence, and ultimately it's a civics issue as well, because we're thinking about at some point presenting this to a jury. How does it play out in front of a trial jury? So if this reporting is correct, and every indication is that it is, and we've got Donald Trump again talking about his possession of this document with Mark Meadows, perhaps other people, military document, plainly classified in some nature. And again, as I said before, it goes to this issue of intent. The reporting, as Joe, you just indicated, is also that the special counsel, the special prosecutor here, may not have a copy of that. And does that compromise in some way the prosecution, the investigation going forward? It's a great question. The short answer is no, it shouldn't. Why? Because even if the prosecution doesn't have the document itself, this kind of thing can prove intent generally. Even if the government is unable to say, well, we don't know what he was, the specific numbered classified document, Joe, as you indicated, we don't know which one he had before him at that time. It certainly indicates generally that he knew what? He knew what classified documents were. He knew that he was not supposed to have them as a former president. He knew about their significance. He knew that he's talking to other people about those things. And so even though this particular document may not be in their possession right now, it plainly goes to those documents that are or were in his possession that the government can establish. So it is a much bigger issue than beyond just the specific content of the document, although I should not in any way diminish the significance of that. If this document is one of the sort that does in fact talk about our military position overseas, that's no small deal, right? That's a big deal. And it could be, if it is the focus of a particular count, then probably the government needs to identify it. The question, of course, we're relying upon some of this reporting. We don't know exactly what Jack Smith has. I suspect he smiles on a regular basis when people like me now talk about things and speculate about what he may or may not have. But the answer is the recording itself, reflecting his intent, is I would argue even more important than the actual document. It may well be that Jack Smith, going back through all of these hundreds, if not thousands, of documents that were acquired during the course of the search back in August, the voluntary compliance to some extent with the subpoena, maybe he's got it somewhere. The indication is probably he doesn't. And that raises the second question that I think is packed into your very good thought there, Joe, which is, what do you do about that? If you find out, wait a minute, we don't have this document, it means that there's something else out there. And I think, Joe, that's exactly what you're describing here. The question then is, what do you do about that? Plainly, he's talking to a lot of people in front of the grand jury, people from Mar-a-Lago, people, the staff around Donald Trump, and you can ask them, hey, do you know anything about this particular document presented when the former president was talking to his former chief of staff in New Jersey? Do you know where that is? Do you know what happened to that document? And ultimately, the question is, many people ask, well, gee, can you search the New Jersey property? The question always is, do you have probable cause to go back in? Do you have enough to indicate today? Again, this is a conversation way back in 2021. Do you have enough confidence today that if you go into that Bedminster location, you will find evidence of a crime? And just on this alone, we don't know what else Jack Smith may have. Just on this alone, you plainly don't have that. A judge would look at me or look at Jack Smith and say, you know what, this is not current. This is not up to date. How do I know that today this document may be there? Highly likely that it's not there anymore, right? But so you could pursue that idea if you've got probable cause to believe that this or some other document is out there, whether it's in Bedminster, Mar-a-Lago. Then you can go back to a magistrate judge and say, here's our probable cause. But on this alone, you probably can't get this through a search warrant, but certainly could pursue other people who may know about it, may know where it is, may in fact have seen it at some point, whether it's there or some other setting. So great question. These are the kinds of things that people in Maine Justice right now, Jack Smith's staff and others, are looking at and are planning certainly to pursue. I suspect they know more about this document than we know, even perhaps about its location. So, Joe, thanks so much for the comment. Great observation, as always. Catherine, also on the line today. Glad to have you with us this morning on Morning Cannolis. Your thought or comment?
Hi, Jim. I just have a question that's been bugging me ever since this whole document thing happened.
Yes.
And like everybody I know, and you, I'm sure, we've taken things out of the library,
Right.
and they know when they're gone and who checked them out.
Right.
Doesn't the government have a list of what is missing, and can't they find out who was the last person that was responsible for that?
Right.
I mean, even the documents that Biden had, they should have known didn't
Right.
come back.
Right.
You know?
Right. But
And I'm just wondering why they don't have that. So
Right.
I'm going to hang up and listen to your answer.
Great, Catherine. Great question, and the answer that I will give is a great question, because it does underscore one of the flaws that I think all of this, the matter involving Donald Trump, the matter involving Joe Biden, the matter involving our former vice president that's now been closed. How are we not keeping track of these things? Right? We've got the Dewey Decimal System. We've got checks and balances at our local library, Catherine, as you just indicated. We know where our books are. How is it we don't know where our classified documents and other non-classified documents are? There should be a system. I have no doubt right now that inside the government, Department of Justice, all areas of government, indeed, the current president has directed some of this to happen. We need to get better hold of this. We need to have established more of the library system, Catherine, that you've talked about, so that presidents, vice presidents, when they leave, cannot simply throw these into boxes. There's got to be some monitoring. Yes, there's some recording, there's some numbering, as Joe sort of indicated, but all of this reflects upon the fact that we do not, stunningly, in 2023 in our nation, have that unified system of coding and of numbering such that you can say, gee, this is document number 15605-2323. We don't have that. And we desperately need, there are lots of classified documents out there, lots of materials that should not be in the public domain. All the more reason, Catherine, you're a very good question, that this needs to be a focus of our government agency-wide, not just in our military area, but agency-wide classified documents. We need to do better than this. And again, maybe we need to follow the instruction of our librarians who are out there. So great observation, Catherine. Appreciate it very, very much. Great insight. And let's also talk this morning to Mark. Mark, glad to have you with us this morning. Glad to have you a part of our program.
Yeah, it's probably been brought up before, but what I found kind of amusing is that one of the former president's apologists was saying, well, when Donald Trump jumped on the plane right before Joe Biden was inaugurated, he was still president, so he could take whatever the hell he wanted to take with him. And I find that just indicative, to me at least, of criminal intent. I was never a lawyer. I mean, I was an auditor, and so I had to look over, documentation as a form of evidence, and that look to see what had happened and various things, and that it's clear to me, and I'm just a layperson, that I just think that indicates Donald Trump's intent to profitize off his presidency.
Right. And Mark, when I would remove from your sense the word just a layperson, because it's exactly people like you who are on grand juries, who are on trial juries, petit juries. Your assessment of these things are accurate, right? It's not just the lawyers who play around with words like intent and scienter, those kinds of things. It's actually it's people just like you, Mark. The law should be premised upon common sense and an understanding of how people behave. That's how I, as a prosecutor, used to present cases. I still do, and not as a prosecutor, but as a civil litigator. You appeal to someone's sense of common sense, right? And so, again, your account about the president's conduct getting on the plane, even after that, as he said repeatedly, I can declassify anything I want just by thinking about it. Well, that's just plain not true. We know that that's not the case. It's never been the situation. All of these kinds of statements. And Mark, I think your point is very well taken. Every single one of these, including the time getting onto the plane, does go to intent. intent, right? It shows a purpose. It shows, I'll use the word malice, which is not really part of the specific statutes probably that Jack Smith is looking at, but intent to do something wrong. And you know what you're doing, you understand you're not supposed to do it, and you're doing it anyway. And I would offer, Mark, that supporting your observation about this and other engagements and other things that the former president said, he repeatedly confirms that he knew, that he had this intent. Even in his most recent interviews on these talk presentations, CNN, Fox News, these town hall meetings, he doubles down and he continues to say, yes, I had a right to have these documents. I had them. Of course I had them. Well, Jack Smith, you have to know, is taking all that down. He's recording all that. And we may well see some of that evidence in a trial if indeed a grand jury returns an indictment based upon a finding of intent to possess, intent to take, to maintain these documents. So, Mark, a very good observation about this. And indeed, it's exactly the kinds of common sense observations that juries, both grand jury and a trial jury, bring to the assessment of all this evidence. Jack Smith's got a lot of things on his plate, right? And one of the concerns that we all have is, as you look at, again, the Mar-a-Lago documents matter, which is huge and sprawling, and then you look at the January 6th matter, the election of November of 2020, all those things arguably even larger. All of these things huge in their dimension. One of the great challenges that Jack Smith and other prosecutors have is not only establishing intent, which probably can be done now based upon the things that we do know. And as I said before, Jack Smith probably has even more evidence based upon things that people have said in the grand jury, not in the public domain, looking at these documents, looking at the results of the searches, all those kinds of things, looking at the statements that Donald Trump himself has said on the public domain. But he's also got to focus ultimately on some specific prosecution units. He's got to be out there at some point saying, okay, I may not be able to charge everything in both of these buckets of cases, the January 6th matter and also the Mar-a-Lago. I've got to charge something. And that's also, I think, the continuing abiding frustration that some of us have at an increasing level. It's now time to bring these matters to justice through our federal system. Look forward to that happening, perhaps as soon as this summer, as Jack Smith and the Attorney General tell us what grand juries in the federal government are doing about all of this. When we come back, our final segment here on Morning Cannolis, finally, we're going to talk about the Supreme Court, a couple of important cases on its docket this past week. Stay with us for that discussion about cement and grocery stores as we come back here on Morning Cannolis. We are back this morning, this great Saturday morning. We're talking now about our United States Supreme Court. And as you recall well, in previous incarnations of this broadcast, we have talked about some of the major cases the Supreme Court has issued in this term, coming to a close. Technically not in June, but coming to a close practically as it issues decisions in the next few weeks. Lots of those coming up. We've talked previously about these major decisions in three cases. A case involving Sackett, in which the Supreme Court dramatically curtailed the capacity of the Environmental Protection Agency to protect us from water pollution, and specifically under the Clean Water Act, joining a case that they decided last term, that dramatically undermined the capacity of the EPA in enforcing the Clean Air Act. So the Supreme Court continues to diminish and withdraw the capacity of the EPA to keep us safe and secure in this environmental area. They decided another case in which the Supreme Court will not hold tech companies like Google and Snapchat and others, online website provider companies, liable for the user posts. Cases, again, involving Twitter and those kinds of things, Facebook, not being held liable for the things that are posted by the users of those social media platforms. And also recently, case involving Andy Warhol and Prince, finding that Andy Warhol, during his lifetime, did in fact violate the copyright of a photographer who had taken a picture of Prince. Andy Warhol had turned that into his own pop version of it, a major issue in the area of intellectual property, just like the other cases, significant cases along the way, about 60 altogether being decided by the Supreme Court. I cannot say that these next two cases fall in the category that are that attractive, but they're important nonetheless. And among the 60 cases, we had two this past week. One, as I said in the teaser, involving cement, the other involving grocery stores. The case involving grocery stores actually comes out of the Seventh Circuit. We're here in Wisconsin, in Illinois, and Indiana. This particular case is a unanimous opinion coming out of the Supreme Court just on Thursday. Give you a little bit of a civics background on this one as well. The case involves the False Claims Act, the FCA. What does the False Claims Act say? Well, basically it says a defendant, anyone, can be liable for submitting a false claim to the government. Makes sense, right? If you are seeking payment, if you act knowingly, if you knowingly, purposefully, with that intent, once again, the scienter, submit a document, a request for payment, which you know is inaccurate. Happens a lot, unfortunately. And the statute defines that as acting with actual knowledge, a deliberate ignorance, or a reckless disregard. And at issue in these two cases is United States ex rel. Schuett versus Super Value, that's one of the grocery stores, and also United States ex rel. Proctor versus Safeway. That was the other one, was whether the defendants, that is the grocery stores in those cases, whether their subjective belief about whether there was a violation here, a knowing submission of a false claim, is relevant to determining their knowledge, if its conduct represented an objectively reasonable interpretation of the relevant issue. And so the lower court, the Seventh Circuit right here, cutting through all of that legalistic stuff, said the defendants could not be found liable for their false statements, which I'll get to in just a moment, under the FCA, under the False Claims Act, as long as they were able to come up with some objectively reasonable interpretation after the fact of their submission, even if they never actually believed that interpretation, all right? And that was the case going up to the Supreme Court. The Supreme Court comes back and says in a decision that vacates that lower court decision, says, no, Seventh Circuit, you're wrong about that. Justice Clarence Thomas, subject of a lot of our discussion here this morning, explained that for the unanimous court, that what matters in a false claims case is whether the defendant knew the claim was false. And so if the defendants here, these grocery stores, correctly interpreted the relevant phrase and believed their claims were false, they could have known that their claims were false and therefore could be subject to prosecution. Now, where does this case come from? Well, it turns out that under the rules of Medicare and Medicaid, something called the Federal Employee Health Benefits Program for prescription drugs, pharmacies cannot collect more from the government than the usual and customary price for a drug, which is defined sort of as the cash price charged to the general public. There are whistleblowers here who came forward and said these grocery stores are doing this illegally. They're charging more than they should. That's why you get these strange names of these cases involving the whistleblowers. Their names are Schuett and Proctor. And again, the district court determined that the defendants' discounted prices were the usual customary prices. The primacy prevailed before the district court in the Seventh Circuit. However, on the question of whether they had knowingly submitted the false claims, which again the Seventh Circuit said was impossible as long as their acts were consistent with an objectively reasonable interpretation, even if they didn't actually believe that interpretation. Justice Thomas rejects that, says no. These companies, these grocery stores can in fact be held liable. Says that the pharmacy's submissions of the false claims might have been a forgivable mistake if they had honestly read the phrase as referring to retail prices, but here that wasn't the case, and for that reason the case goes back down to the Seventh Circuit, back down to the district court. False Claims Act, grocery stores still in trouble. Not criminally, but under the False Claims Act for submitting these false claims. And then in our final moments here, a case involving cement. This case is very important. Not only the other case is important too, this case involving labor. The Supreme Court ruled on Thursday that federal labor law did not prevent a union from having potential liability for damage that some of its members caused during a strike. And that the state court, and not the National Labor Relations Board, should resolve questions of that liability. The majority of the court, and again, the majority is interesting, get to that in just a moment, found that if some accusations by an employer, and this particular employer named Glacier Northwest, they're a cement company, they provide cement services, cement construction. If their accusations by an employer were true, these actions during a strike by a local Teamsters union were not not protected by federal law because the union, the labor folks there, took some affirmative steps, according to the court, to endanger the employer's property rather than some reasonable precautions to mitigate that risk. And therefore, the Supreme Court said that case, that claim by the employer, can be handled by the state court and not the federal agency, the NLRB. Interestingly, this opinion, get a hold of this, written by Justice Amy Coney Barrett and joined in by Chief Justice John Roberts and also Justice Brett Kavanaugh, and then also by Elena Kagan and Sonia Sotomayor. You've got a very interesting bedfellows there. 3 conservative justices backed a more sweeping concurring opinions. They concur in the result. And a single justice, Ketanji Brown Jackson, dissents in all of this. The case, again, involves Glacier Northwest versus International Brotherhood. It involved these unionized employees of this concrete mixing company and a pouring company who walked off the job during contract negotiations, leaving wet concrete in their trucks. That's the destruction was alleged here. The employer allegedly suffered some substantial monetary damages. The court saying that's cognizable, and the state court don't have to go through the federal system to get that resolved. A major case in labor, regarded as a defeat for labor, but again, the standard still remains under the NLRB in other situations. We're going to be talking a lot about the Supreme Court in the future. Decisions coming up on June 5th, 6th, 12th, 15th, 20th, 22nd, and 26th, all of those decision days. Major cases being decided by our Supreme Court. Come back in those future weeks. Join us again for our second year on the air talking about the Supreme Court and other cases. Thank you this morning. Have a good week, everybody.